The notice on petition for appointment of a conservator or a protective order. Hi, I'm Darren Findling of the Probate Pro. We're going to examine SCAO form PC 668, SCAO for State Court Administrative Office, PC for Probate Court. This form, PC 668, is used in a very narrow context. When a petition for appointment of conservator has been filed with the court, between the date of the petition and the hearing date, notice is given to the person that is being sought conservatorship over. And that notice advises them of their rights and gives them a sense of what's going on. With all of these SCAO forms, they are created by various statutes or court rules. And here, the floating yellow arrow reflects those particular statutes. And these statutes can be confusing to read. We urge you to look at them, but we really urge you to be working with a skilled, competent probate lawyer that understands the statutes and court rules, knows how to navigate through this process, knows how to address a court and work their way through the system, because without a lawyer, it's tricky, not easy to do. So when a petition is filed, notice is provided to the interested parties, and then of course there's a hearing on the petition. In this particular case, it's for conservatorship. Now, to differentiate between a conservator, somebody handling finances, legal, the assets of an individual, versus guardianship, which relates to care, custody, placement of an adult, an individual. So this is specifically for money or legal related issues. Let's work our way through the form. Top left corner is the county upon which the probate conservatorship is the venue and county court. Top right corner is the case number. At the top, in the matter of, is simply the name of the person in which this conservatorship is being sought on behalf of. Now, there's a big, bold, squared section that says nature, purpose, and legal effect of the appointment of conservator. And the idea is that when the petition is filed, this gives an understanding to the individual who's being sought over conservatorship of what even a conservator is. Most people don't know the term. They may be more familiar with a guardian. They may be more familiar with the term power of attorney. But the use of the term conservator is often a new word that's foreign to most people. So in this particular case, the court is defining that term. And this particular form would generally be given by the guardian ad litem, who goes out and does the visit between the date of the petition and the date of the hearing. So they hand them the notice, and then they talk about that there's a petition pending seeking the appointment of a conservator. Here's what a conservator is. Here's what it means to have a conservator. The next section says that if a conservator is appointed, they'll have the powers over you, the person that is being sought conservatorship over, for the estate and all business affairs. So in essence, they stand in your financial shoes. They stand in the legal shoes to be able to handle all of your financial affairs. Now, these powers can be quite broad, or they can be limited in scope, depending on how the court rules. Again, the next section simply says that anybody who has been appointed by the court, a person has been appointed by the court to fully explain the matters to you. That's that person that's either a guardian ad litem or an agency or person that has been appointed. In this case, they define the term guardian ad litem, another term that's incredibly confusing to people. Why they use the term guardian ad litem when there's a guardian that's involved in guardianship just is beside me. But that person or agency, that guardian ad litem, is coming out to explain the matters to the person, explain the pending proceedings that are going on. That guardian ad litem is there to be the eyes and ears of the court. And they should answer questions that you have, explain the process, understand your rights, understand what you can do if you object to either the need for a conservatorship, the scope of the powers of that conservatorship, who is requesting to become the conservator. These types of questions should be explained to by the guardian ad litem and discussed and addressed. Below are the rights. These are the rights that we want to make sure that that guardian ad litem explains fully to the person upon which the conservatorship is being sought. Let's work our way through these. One, you have the right to secure at your own expense an independent evaluation. So you say, you know what, my mental health is good. My mind is clear. I don't have the disability that you're alleging. you can secure at your own expense an independent evaluation of your condition. 2, you have the right to be present in person at the hearing. Now, in person is a little tricky because often some of the courts are using digital means of communicating like Zoom, but you have a right to be present, to face in front of the judge, face the witnesses, face the petitioner. You have a wish, if you wish to be present at the hearing, all practical steps will be taken to ensure your presence. So for example, if you're in a facility, the court can use technology to allow you to have a presence at the hearing. 3, you are entitled to be represented by an attorney. So if you object or indicate that you don't agree, you can say, I'd like an attorney to represent me in this conservatorship matter. You object, you have a right to an attorney. You don't have to take that up. You can simply say, I agree, I consent to it. 4, you have a right to be present. You have a right to present evidence at the hearing. So it could be your own medical, it could be testimony, it could be documentation to support your objection if you are objecting to the conservatorship. You have the right to cross-examine witnesses at the hearing, including a court-appointed physician. So if the court has appointed a doctor who did an evaluation, you have the right to cross-examine those witnesses, as well as the physician or the mental health professional. And again, if you have an attorney, that attorney would perform that role for you. You have the right to a trial by jury. Yeah, this is one of those cases in which the burden is clear and convincing evidence, and you have a right to a trial by jury on this issue. You don't have to take that right, of course, but you do have the right. You have the right to request that the hearing be closed to the public. You may say, I don't want anybody else to be able to view or be a part of these proceedings because of the confidentiality, the personal nature involved here. I don't want this information disclosed or out to the public. So you can ask for a closed hearing. And 8, if the court determines that a conservatorship is necessary, you have the right to nominate a person or corporation. So what this means is that if the court finds that you're in need of a conservator, you have a voice. They don't just get to pick whomever they choose. You have a voice to be able to nominate the person or agency or entity that you'd like to serve in the role of conservatorship. So these are the general rights that are provided to a person upon which a conservatorship is sought, or if there's a protective proceeding, these are the rights. Now again, these are the most basic rights as set forth in the statute. There's a lot more to this. The statutes that are referenced here and the statutes that make up the conservatorship and protective order proceedings. But these are the rights that are to be provided by the guardian ad litem when they come out and do the visit for purposes of a petition for appointment of a conservator. At the Probate Pro, we are passionate about everything probate. If you have questions about this proceeding or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.